Yes, Mr. Campbell.
My Lords, I was just finishing off my tour of the materials before
Thank you.
The trial judge, before he made the trial order. We were in the supplemental bundle, and I think we had probably exhausted the claimant submissions, and my Lords, I know, have read those, and in particular the paragraphs to which my learned friend has referred you. The last item was the travelling draft of the order behind tab 10.
Thank you.
You'll see at page 92 that the recitals follow the same approach that we discussed this morning in relation to the trial order. They are chronological, and the red wording in the fourth recital reflects Lufthansa's proposal. And we've seen from the relief judgment that the judge says he wasn't clear what was meant by fallen away, but I have shown you Mr. McCulloch's statement, which said that it meant the same as do not need to be decided. And again, we come back to the same ambiguity, and I give the same answer to the question about that ambiguity. Then paragraph 11. So the black text is agreed, and if one considers the black text in isolation, it says the parties have liberty to apply for further directions on the inquiry account and in relation to the determination of the adjourned issues. So the agreed text, we say, was in accordance with the submissions I've made to this court, that the adjourned issues were still in play, in particular for a quantum hearing as necessary. And it is inconsistent with the proposition that Lufthansa had abandoned the issues. And then we have the proposed qualification in red, insofar as may be necessary following an appeal. Now, I have to take on the chin the way that this is being characterised in our submissions about what it's there for. But if one considers what it actually says, which is important, and an important part of the context before the trial judge, what it says is that nothing will be done about these further issues until after the appeal has happened. In other words, they are not something that the first instance court needs to worry about in the immediate aftermath of the trial judgment. On the other hand, once an appeal has been resolved, the qualification lapses and the liberty to apply is available. So if one just considers that wording as against the present permission...
How does that work if there's no appeal?
Well, that's what it says, any appeal. If there is no appeal, then it's as if there's no red wording. If there is an appeal, then once it's happened, the question is it necessary to apply in relation to the adjourned issues?
But the red insertion is not just, it doesn't just have a temporal effect. It also introduces a concept of necessity consequent upon an appeal, which we know what that was directed towards because we've seen the submissions that lie behind it. So it wasn't just park until after the appeal. It was meaning this will only arise if there has been an appeal that changes the basis of judgment.
I have to accept, and I do, that the submissions that accompanied the draft order directed the judge to that reading. My submission is simply that on the face of this wording, that limit is not brought into play, and it is that there is a greater freedom. And if either party says, well, it's necessary now to resolve these issues, they are able to apply.
Well, when was looking at competing suggestions in a draft, then the only way that you can consider those is as reflecting what is said by the parties in their submissions. I mean, unlike an order, they're not freestanding.
I certainly don't resist the proposition that the submissions have to be considered and had to be considered by the trial judge.
As I understand this, the wording in black is entirely consistent with the position that the defendants were taking prior to the consequential hearing, namely that there would have to be, that you were pursuing the adjourned issues and there would have to be directions
I believe that's
in that
correct.
regard. So that's entirely understandable from their point of view. But you were saying, no, we're not pursuing them, except possibly after an appeal. And that's also consistent with your wording, and the judge's decision was, well, no, I'm not going to let you, I'm not going to give a direction giving you liberty to revive them after an appeal. I accept that you've abandoned them. I accept your position that you've abandoned them. Hence getting your costs, which again the defendants had said in 12 carved out the adjourned issues. So the judge conventionally has looked at the submissions and accepted the defendant's submissions in some part and accepted your submissions in some part, and that's where we get to where we get.
Yeah, and one still has the overarching ambiguity about those submissions and all those materials, and indeed this order, and because it all, from the very beginning all the way through, it all makes sense if you just parenthesize at the liability stage. And if you don't, then we've got into the difficulties, which of course is why we're here. Yeah, but of course, I accept that with the benefit of hindsight, there would have been more, there would have been express caveats to the position that was put before the judge. But these things happen sometimes in litigation. And the decision for my lords is whether this consequence is one that is appropriate given what transpired. That's the decision that broadly arises on the second appeal. So those are the materials. I think you have had my submissions in relation to why the judgment was wrong if it has the meaning of shutting us out. There was nothing approaching an unequivocal abandonment. There was, at worst, significant uncertainty about the scope of what was being said, but there was no voluntary statement of abandonment. Related to that, we say there is it's all part and parcel of the same problem. The judge's reasoning, if we go back to the trial, the relief judgment, briefly, paragraph 2. So this is core bundle 16. As part of his reasoning, the judge observes that Lufthansa had not fortified its position on the adjourned issues by stating that it might want to argue for a wider remedy based upon them. Now, I've explained to you my position that that point about a wider remedy is itself ambiguous, but we also say that this reasoning gets the onus wrong. The default position is that valuable pleaded allegations in relation to established legal rights remain available. It's not for Lufthansa to justify why it does not want to abandon them. And this is an approach that follows through the rest of the judgment. The judge seems to think it was for Lufthansa to justify that. And we say that that's really the wrong starting point. And again, the sort of thing that would surely have been worked out had there been an oral hearing. But there we are. My lords, I think
so the way, looking at paragraph 2, is this the way that it works, that you're going to have a quantum trial? They're going to try and chisel away at your claim. You say that you're going to resist that on arguments of principle, but you wish also to have these arguments available to you. Is that what paragraph 2 means?
I don't, as I explained, I'm not clear what paragraph 2 means about a wider appeal, because we have made good a claim to a quantum stage. We have got in the trial
Yes.
order.
But I'm only looking at, sorry again to speak over you, but the defendants are saying that little or very little profit made on the particular acts of infringement, you say that that's wrong in principle. And so the headlines for the upcoming quantum trial, as described there, but I'm just checking that I've understood what at least the judge is saying, is that that's the main event. What this is about is you having other strings to your bow at that point. Is that where we are?
Are you looking at?
Paragraph 2 of the deputy judge's judgment.
I'm so sorry. That's my fault, my lord. We should be in paragraph 2 of the trial, the relief judgment, which is tab 16.
All right, my fault. I'm sorry about that.
No,
but since I lighted there,
Yes.
is my understanding correct?
So I'm afraid.
That's at page 122.
Yes, 122.
Right. And now,
Because I was in the wrong judgment, I didn't quite follow the question. Could I invite my lord to repeat it?
right. As I understand paragraph 2, you're going to be making claims for profits. They're going to be saying that no or very little profit arose from the particular acts of infringement on which you succeeded. You say that they're wrong about that. So that is the, as I described it, the main event.
Yes.
But you wish, through this appeal, these applications for appeals, to have other strings to your bow in meeting the defence.
No, I wouldn't characterise it like that. The position is that the defendants think they have an argument with one bound they are free, which is that although there may have been a long course of infringing dealings, the particular act alighted upon by the trial judge as giving effect to liability wasn't one that has profit associated with it. And therefore, on this account of profits, you get nothing. They didn't make profit out of being jointly liable for the acts of their customers. So it's pretty fundamental.
Right, but on that argument, you're entitled to rely upon the found infringements and the unresolved matters.
I am.
So you can deploy those
Yes.
to meet that argument.
Yes.
And that is what I was describing as it were, the main event.
Right.
But what you also wish to be able to deploy is arguments that might possibly arise out of the adjourned issues.
There is not perfect overlap between the utility of the unresolved issues and the adjourned issues. So there are some matters which, if I lose this appeal, there are some profits that are absolutely beyond any reach.
Right, which are not conditional upon your failure at the quantum hearing in any degree. They're ones that you couldn't sustain at the quantum hearing, you say?
Without the adjourned issues, correct.
All right.
Correct.
Thank you. Now, I better now make sure that I've understood the point that you were making with reference to the correct paragraph.
So, my lord, I was in the...
Right, I think I'm now at page 112, if that's where
Yes,
I ought to be.
pre-
Thank you.
pre-
Would you mind
precise.
making that point very briefly again?
Absolutely. The point I was making simply this, is that the judges approached it on the basis that there needs to be a justification from the claimant about what it might want to argue further down the line. And therefore the default position appears to be, in the judge's view, that without that justification, these legal rights get set aside. And my point is simply there's a matter of onus that's not right. If I've got legal rights, then there needs to be some unequivocal renunciation of those rights. I don't have to come to court and explain why I might still want them.
Right, thank you.
My lords, I don't think I need to say anything further about the second appeal. I'm aware of the time. In relation to the relief from sanctions part of that,
Yes.
I think you've got the core of my argument, which is that we say it was not blameworthy.
You acted promptly when it came to your attention.
Acted promptly when it came to our attention, and we were not blameworthy in not seeing the point before then. Plainly, if you differ from me on that, then I'm in difficulty on relief from sanctions. But in those circumstances, we are content for you to take the argument from McCulloch 16 at supplemental tab 26 and the short skeleton argument at tab 9 of the core judgment, core bundle.
Yes, sir. Look at that.
My lords, unless you have any questions about that part of the appeal, or unless I can help you further. Very grateful.
Thank you, Mr. Cuddigan.
Oh, just one point of housekeeping. My learned friends have agreed that they to a 3122 order in relation to the confidential document as the annex to our defence behind tab 23, and I would ask that the court also approve that.
No, I didn't hear. It's me. I didn't hear any of that.
I'm so sorry, my lord. There's a confidential document in the bundles, and because this is an open court hearing, the usual way to deal with that is to ask for a 3122 order to protect the confidentiality of the annex to our points of defence.
Right. Could you reference the document, please? Just
yes, it's tab 23 of the core bundle, and it's the last page is the confidential part, which is the page 192.
right. So that's a single page, page 192, and you will make that part of our order.
I'm grateful. Please. So, my lords, an overview of where we are. This is the 5th occasion on which the terms of this order have been before the court. We have the original post-trial application before Mr. Justice Morgan in July 2020. Then there was the substantive appeal in November 2021. Then there was the application before Recorder Campbell KC in April of this year. Then there was the variation application before Sir Paul Morgan earlier this month. And now there are these appeals. As your lordships will understand, an incredible amount of time and money has been spent, especially in the last 6 months, dealing with the claimant's attempt to reverse the decision that it persuaded Mr. Justice Morgan to make in August 2020, but which it now regrets. Further, matters have moved on significantly since the hearing before Recorder Campbell, the first appeal, because Sir Paul Morgan has confirmed in a judgment delivered earlier this month that he intended the order to mean precisely what Recorder Campbell has held it to mean. And as a result, we say that Lufthansa are in a perfect bind now in relation to the first appeal. Because if this court were for some reason to hold that it did not mean what Recorder Campbell held it to mean, and to agree with Lufthansa, then it would be open to Panasonic to return to St. Paul and have the order corrected under the slip rule to give effect to the intentions of the court, which he has now expressed in plain terms, are consistent with our submissions and indeed what Recorder Campbell has found.
I'm sorry to interrupt you when you've only just started, but a number of questions arise out of what you've said. Firstly, so far as I'm aware, we don't have any recent judgment from Sir Paul Morgan.
It's in the last tab. I'm sorry if it wasn't drawn to your lordship's attention.
Well, I'll be the first to say that I've not read this judgment. It's not a
right.
long one.
I'm obliged. I hadn't seen that had come in, but thank you.
I'm afraid we flagged that it was being. The skeleton was being finalised as it was being delivered.
Yes, I had noticed that. Yes. Very good. Now, second one is this: what relevance does Sir Paul Morgan's judgment of the 10th of October have to the issue on this appeal, or on either of these appeals? Because, so far as the first appeal is concerned, or application to appeal, the question is an objective question of the true interpretation of the order. And subjective evidence from the judge who made it is inadmissible, particularly subjective evidence more than 3 years after the event.
Yes, well, I'm not seeking to rely on the order, sorry, the judgment of Sir Paul in relation to the appeal from Recorder Campbell.
Well, so far as the second application is concerned, the gravamen of the argument is not so much on this hypothesis that the order Mr. Justice Morgan, as he was then made, didn't accurately reflect his intentions. The argument is he was wrong. And again, how does his later judgment assist on that question?
Well, in that respect, my lord, we say it is admissible in the same way as your lordships may well look at the comments that a judge makes on an application for permission to appeal. Indeed, I recall your lordship did in the BMS, the Apixaban decision recently, you referenced the judge's further comments made in a judgment given on the application for permission to appeal in relation to whether or not a particular point had been run at trial. So in our submission, this court routinely looks at subsequent judgments delivered by courts in order to help it decide whether there are admissible and allowable grounds of appeal. And so we say, for the same reason, the Sir Paul Morgan decision is admissible in relation to the decision you're being asked to make as to whether or not he fell into error when he came to the conclusion he did based on the materials that were before him at the relief judgment hearing. So I was going to take you to that. We say that we win anyway. It's my overarching submission, but there is additional support.
Yeah, but what's this? I mean, I can see from just scanning this document that Lufthansa made an application, 291, under the slip rule. And we're going to have to, are we not, at least, even if it's of no relevance to our decision, understand where this fits in the procedural sequence of events in this case, because it's an application which was issued on the 28th of June and amended on the 4th of October. And in this case, my lord gave permission to appeal to this court on the 17th of August, and the judge is here returning to the anvil on the 10th of October. And what's going on here?
Well, my learned friends were very keen that Sir Paul should hear the slip rule application before this court heard these appeals. And they pressed on more than one occasion, listing, and there was a hearing before Mr. Justice Mellor, where he ordered that the slip rule application should come on forthwith, without consideration of convenience to counsel, and it was duly heard at my learned friend's behest.
Right, so without then needing to dive into the judge's thought processes, we can start by taking away, can we, that in a further effort to remedy its situation, the applicant in this court made an application under the slip rule which failed.
My lord, yes. And so the point
Do we need any more than that from your point of view?
Not on the appeal against Recorder Campbell. I would seek to draw your lordship's attention to various observations that Sir Paul makes in his judgment, which are entirely supportive of our submissions on the application for permission to appeal his judgment. So I would like to take you to it later. But the point I was trying to make in relation to the appeal from Recorder Campbell is we now have the judge explaining what he meant in his order and why he meant it. And so if for some reason your lordships were to say that Recorder Campbell was wrong and an objective interpretation of the order that the judge made is different to the one that Recorder Campbell arrived at, then it would be open to us to return to Sir Paul under the slip rule and say, well, the objective interpretation of your lordship's order, which the Court of Appeal have held, is different to the intention that you have now expressed in a judgment, and therefore the order ought to be amended under the slip rule to reflect Sir Paul's intentions when he made the order. So the point of that is to say to your lordships that there is no point in my learned friends pursuing the appeal against Recorder Campbell's decision, because even if they were to win, it's now clear that Sir Paul meant what Recorder Campbell has said he meant, and so it would be open to us to go back to St Paul and tie him again with a slip rule application to say, well, for some reason the Court of Appeal have said that your order doesn't mean what you thought it meant, please will you amend it? Now, I'm not, we say that shouldn't happen because your lordships should find that Recorder Campbell was right for the reasons he gave, and so that never arises. But we say, even if my learned friends persuade you otherwise, then it's really nugatory, his appeal, because things have moved on at my learned friend's behest, and Sir Paul Morgan has given the views he has about what he thought he was ordering at the time. So that's the point we make about Sir Paul's decision in relation to the Campbell appeal. And then on the appeal from Justice Morgan, we say that is hopeless for multiple reasons, particularly because, as this court has already commented, Sir Paul was simply giving Lufthansa what it was asking for at the time. And for better or for worse, Lufthansa told Sir Paul, or Mr. Justice Morgan as he then was, that the adjourned issues would never need to be determined for understandable tactical reasons at the time, namely to recover its costs. And there's no basis to criticise the judge for doing exactly what Lufthansa asked him at the time, which means that the second application should also be dismissed on the merits, even if my learned friend could persuade you to grant relief from sanctions, which is a very major additional hurdle.
But it's more than that they wouldn't need to be determined, it's that they wouldn't even seek directions in relation to them.
Yes,
there's nothing further other than
absolutely,
costs, is what he said.
Absolutely. We respectfully agree. And finally, my lords, just by way of overview, note what is not before you, but which could have been. My learned friend argued before Mr. Recorder Campbell that even if the order meant what Recorder Campbell found it meant, it should not be held to constrain the scope of Lufthansa's account of profits. This is 147 of my learned friend's skeleton before Recorder Campbell, and we can provide copies if your lordships wish. But Lufthansa have not sought to appeal that aspect of their application. Their appeal is limited to the objective interpretation of the trial order or the correctness of the decision of Mr. Justice Morgan to make the trial order in the first place. And so neither of these appeals seek to challenge the approach to the pleaded issues in the points of claim, assuming the order was correctly made and interpreted. And it's now far too late to raise that for the first time. So all these points about fairness simply don't arise on the two appeals which are before your lordships today. And if my learned friend had wished to try to pursue that point, he needed to have appealed the order of Mr. Recorder Campbell in that respect. Finally, just on a point that arose this morning, which doesn't really arise out of my learned friend's submissions in writing before you, is his attempt to rely on the parallels between the unresolved issues as dealt with in the judgment, in particular 286, and the adjourned issues. And our response to that is simple. We can't be in a worse position because we haven't sought, for whatever reasons, to appeal the decision of Mr. Recorder Campbell in respect of the unresolved issues. And those are going to go to the account. And your lordships aren't being asked to interfere with that decision. But we say there is a clear distinction between the position of the unresolved issues and the adjourned issues at trial and in the order of Sir Paul Morgan and Recorder Campbell's interpretation of it. There is, as my Lord Justice Phillips has pointed out, identical wording is not used in paragraph 286 and in the subsequent order that Mr. Justice Morgan made. And there is a material difference between the points because the unresolved issues were all run before the judge. They were part of the trial. And it was only in closing that, in a discussion between my learned friend and the judge, it became clear that the judge didn't need to resolve them then. And that is in contrast to the adjourned issues, which were never run before the judge. And we see that distinction reflected in the first recital in Mr. Justice Morgan's order, where he refers to the issues which were tried, which includes the unresolved issues, even though he didn't go as far as making a decision on them, and the adjourned issues which were never tried, and which therefore a separate issue arose as to whether they were going to be pursued and what the consequences on costs would be if they were not. And that is part of the background, important background, we say, which feeds both into Recorder Campbell's judgment and that of Mr. Justice Morgan. So with that, my lords, I was going to turn to the appeal against the judgment of Recorder Campbell, and I'll go straight to his judgment, which is in tab 18 of the core bundle, if I may. And as my learned friend explained, the first point he deals with on pages 123 to 126, it is the legal test that he should apply, and he held that it was a question of justice and convenience based on the test defined by Mr. Justice Norris in Perini and Mr. Justice Burse in the Tunin case. And although that was hotly disputed by my learned friend before Recorder Campbell, what the test was, he is making no challenge to those findings of Recorder Campbell on appeal. In fact, for the first time this morning, he seemed to try to rely on that. But we say that is all part of understanding the difference, the distinction that Recorder Campbell made between the unresolved issues and the adjourned issues, as my learned friend acknowledged. So that takes you up to paragraph 20, and we note also in paragraph 20, it's clear that the Recorder doesn't seek to draw parallels between this case and an application for strikeout. And again, that was an issue that was live below before him, but doesn't appear to be pursued by my learned friend anymore. Then Recorder Campbell turned to the principles underlying the interpretation of a court order. And again, there's no dispute about the principles that he sought to apply below or on appeal. And in particular, he sets those out in paragraphs 31 to 33. And we rely on 31.3 in particular, in the quote from JSC BTA Bank. The words of the order are to be given their natural and ordinary meaning and are to be construed in their context, including their historical context and with regard to the object of the order. And then Lord Justice Flo, as he then was, went on to quote from Sanssouci in 32, and he makes clear, Recorder Campbell makes, this quote includes the observation that the reasons given by the court for making the order at the time that it was made are part of the admissible material, and we agree with that. And then he goes on to quote a short passage from Sanssouci at 13. But could I also just take your lordships to the case itself and just show your lordships the paragraphs around it, because they're also helpful guidance. So this is in the authorities bundle at tab 9. And we see that the arguments in Sanssouci were summarised by Lord Sumption in paragraph 12. And you'll see the argument was there that as there was no ambiguity in the wording of the order, that was the end of it. You see particularly the last sentence. In the absence of any ambiguity in the language of the order, it should not be construed by reference to the limited reasons given for making it. And we say that's really reflective of my learned friend's arguments, particularly in writing on this appeal. And he then went on to discuss what the appropriate approach is. And paragraph 13, he says, second sentence of 13, it's implicit in the proprietor's argument is the suggestion that the process of construing the order is to be carried out in two discrete stages, the first of which is concerned only with the meaning of the words, and the second with the resolution of the ambiguities which may emerge from the first. The court's reasons, so it said, are relevant only at the second stage, and then only if an ambiguity has been found. The board is unable to accept these propositions. And that's where he goes on, and that's the quote that you can find in Recorder Campbell's decision at paragraph 32. And then in 14 and 15, Lord Sumption explains why it's necessary to look at the underlying reasoning, and it's not right that you should only look at it if there is a true ambiguity, because those are very rare. That's paragraph 14. And 15, he says, underlines that the meaning of the order of the Court of Appeal in this case is open to question if one does not know the background. And that's why background is important, and he explains that extrinsic evidence can provide the support to understand the order as it should have been interpreted. So, my lords, we say those are all they were properly taken into account by Recorder Campbell, and they are equally to be taken into account on this appeal. My learned friend has sought to rely on the Mackenzie case. He didn't mention it this morning, but he mentioned it in his written submissions, which is to suggest that the Judge Campbell fell into error in relation to looking at recitals at all. We say that case doesn't apply here. It's an old case, 19th century case. It's a Scottish case, so strictly it's not even binding on these courts, and it's all to do with the construction of a deed. And in that case, the purpose of the wording in the deed was set out in the body of the deed itself, and the only issue is whether the explanatory text at the beginning was also relevant. The thrust of the decision is that it wasn't necessary to look at the explanatory wording because it was clear enough from the wording anyway, but even still, the explanatory wording wasn't inconsistent with the way in which it should be interpreted. And so we don't accept that that judgment leads to the conclusion you shouldn't look at a recital at all, and in support of that we rely on the decision of Mr. Justice Burse, as he then was in Frankland and Frankland. That's at tab 4 of the authorities bundle, and perhaps I will just take your lordships to that, if I may. So it starts, tab 4, starting at page 84, and it was all about a dispute between two brothers about the effect of a put and call option in an agreement entered between them. And as you might expect, there were some recitals to the agreement. Those are at paragraph 6, and then there were the terms of the agreement itself, and those are summarised in paragraph 8 and paragraph 16. And this was an appeal to Mr. Justice Burse, and the judge below had said that he didn't need to look at the recitals because he thought it was clear on the face of the terms of the agreement what they meant. And you can see in paragraph 22 of Mr. Justice Burse's decision, he summarised the judge's decision below him, and he said at paragraph 24, the judge summarised the respondent's submissions. The respondent's key submission is that the agreement is clear and against the appellant. The defendant had also cited Mackenzie and Duke of Devonshire for the proposition that recitals are not relevant when there is clear agreement. And then Mr. Justice Burse records that the judge agreed with the respondent, and he records in paragraph 25, similarly, although it's not spelled out, the judge has accepted the submission based on Mackenzie, that nothing would be gained by looking at the recitals because the contract was clear. He then goes on to deal with the appeal. He summarises the appellant's case in paragraph 28, and particularly the second sentence of 28 for today's purposes. He says the issue is one of construction of clause 8.2, and there's nothing in that clause to indicate in what circumstances it applies and when it does not. Therefore, even following Mackenzie, regard can be had to the recitals, and if that is done, then the clause ought to be construed as wide enough to cover this case. And he goes on to agree with that. In particular, in 36, he says, as a matter of language, I do not say anything in the words of clause 8.2 itself, which explains where to draw the line. And then he says in 37, in those circumstances, it seems to me it's appropriate to look at recitals to the agreement. I distinguish Mackenzie on the basis that the reason Lord Halsbury refused to look at recitals was because the terms of the deed were clear, and the purposes of the trust were set out in the paragraphs of the deed itself. In this case, the scope of the relevant clause is not clear. And then he has a second reason. He says, in any event, the overall purpose of a clause and a contract as a whole is something to take into account in the exercise of interpretation, citing Arnold and Britton. And in this contract, an indication of the overall purpose is set out in the recitals. The recitals do not merely reflect the subjective intentions of the parties, since the recitals are part of the words of the document agreed by both of them. And then he goes on to find that the recitals firmly support the appellant's case. Now, of course, I accept that this is a contract case, and so recitals in a contract you might interpret slightly differently to recitals in an order. We say the same principle applies. You need to look at the whole document. The recitals inform the later parts of the order, and it's totally artificial to seek to look at paragraph 11 on its own without looking at recital 4, as my learned friends have urged you to do in writing. And therefore the judge, Recorder Campbell, was right to consider the order as a whole alongside the expressed intention of the order in Mr. Justice Morgan's judgment. And that, we say, all fully supports and points towards the same meaning, objectively, that Mr. Recorder Campbell arrived at based on the submissions below. So if I go back to Recorder Campbell, if I may, back in tab 18, and the analysis starts at paragraph 34. And one of the points made by my learned friend is, this was all done in a bit of a rush, and that explains why the order's not perfect and why things weren't explained properly. But we reject that, and if your lordships look at the recitals and the timing as it occurred, the draft judgment was handed down to the parties on the 17th of July 2020, so that was the first time they had indication of what they needed to be thinking about. The full judgment was handed down on the 22nd of July. Evidence was then submitted. Skeletons were submitted after evidence on the 31st of July, so some 2 weeks after receipt of the draft judgment, and then judgment on the form of order was circulated a few weeks later on the 21st of August. So it can't be said that the parties were unduly rushed, particularly given the guidance in the Patents Court that hand-down hearings should take place within 4 weeks of the judgment, and that is all reasonable and to be expected to be coped with by parties, particularly parties who are well-resourced and can construct the sort of legal teams as we see in the present case. So that's the point on speed. Then we come to the judge's reasoning, and 35, he records that there was a dispute about costs and that the judge ordered that the defendants should pay Lufthansa's costs of the adjourned issues. And again, this is a distinction between the adjourned issues and the unresolved issues, because there was no dispute about the unresolved issues and where the cost should fall, those issues having been tried, albeit not finally determined by the judge in the judgment. And one can understand why, having lost on the certain points of infringement in the liability phase, the defendants chose not to resist an order for costs on the other points that were being run against them, which it wasn't necessary for the judge in the end to determine. But that is a distinction. There was a point taken about the costs of the adjourned issues, and that is something that the judge was asked to determine. Paragraph 36 is where the judge refers for the first time to the recital, and he acknowledges that paragraph 11 is not on its face alone everything, and he goes to the recital which identifies the adjourned issues, and in particular the fourth recital says, upon the adjourned issues no longer needed to be determined in the light of the court's judgment. And he says this, to my mind, this implies there's no such liberty in paragraph 11, since none will be needed for issues which no longer needed to be determined. Paragraph 11 still makes sense, since it is merely setting up a liberty to apply for all other directions on the inquiry or account. Now, my learned friends place much weight on the fact that the parties and the judge were only thinking about the liability phase at this stage of the hearing. That's very difficult to comprehend when the liability phase was over and the only thing which remained for the parties to get on with was the quantum phase. And the quantum phase was the order which the judge was making and being asked to.
The directions were prospective.
Indeed. And so the only time which this issue might arise, other than in respect of a successful appeal, which I'll come on to, was during the quantum phase. And so we suggest that the recorder was right not to arrive at the conclusion that this was only all meant to be about liability, and indeed the parties and the judge were right not to think that this was only a liability issue, because all that remained, and indeed what Lufthansa was seeking at the time, were orders and directions for the quantum phase. Then in 37, the judge records the defendant's argument that the combination of paragraph 11 and the fourth recital discharged the liberty to apply, and he said, well, that's really the same as what I've already found in 36. You can't place weight on the absence of refusal of liberty to apply as being determinative of this issue when you look at the order as a whole, including the recital. He then turned to the markup of the order, and he notes that the parties agreed that that was admissible, and my learned friend doesn't take issue with that on this appeal. And again, we say that is all supportive of the preliminary conclusion that he had already come to. He sets out the markup in paragraph 38. At 39, he records that the recital, and then he says, curiously, it seems the existence of a liberty to apply in relation to determination of the adjourned issues was at that stage not disputed as between the parties. That's fine insofar as it goes, but as my Lord Justice Phillips pointed out in discussion with my learned friend, paragraph 11, the wording after the square brackets in paragraph 11 was what the defendants wanted, because the defendants didn't want to pay the costs, and the reason they didn't want to pay the costs was that they said these adjourned issues were still open. Now, the claimants sought to put in the wording in brackets, and that we submit and is limiting wording to suggest that the only time that the adjourned issues might arise again is insofar as may be necessary following any appeal. And that's what Recorder Campbell found. And we say, therefore, it would be wrong to characterise the wording other than the square brackets as agreed, because you have to take the sentence as a whole. And plainly, the wording in square brackets is meant to change the meaning of the sentence as a whole. And if the wording in square brackets had been left in, then it would have meant that the only time that the parties had liberty to apply for determination of the adjourned issues was in respect of any successful appeal. And so we say there's nothing to support my learned friend's suggestion on a proper interpretation of this, that somehow the black wording outside the square bracket is all agreed, and if you take that on its own, that means that Recorder Campbell was wrong to suggest that overall the order had the meaning that he arrived at. It's really not the right approach to cross out or put a blue pencil through words and then say, oh, well, it means something else, and that's not in dispute, and therefore the judge was wrong to reach the conclusion that he did. He doesn't place any weight other than saying curiously, but we say that the explanation for him making that observation is that the defendants wanted the wording, as my Lord Justice Phillips had already pointed out. Then Recorder Campbell goes to the judge's explanation, and we say this puts it beyond doubt once you read what the judge said about the various paragraphs. And he records in paragraph 2 that there is an issue as to costs. And then the underlined part of paragraph 2, underlined by Recorder Campbell, the only other matter which I need to refer to is that the claimant wishes the order to provide for there to be permission to apply in relation to the determination of what is defined as in the order as the adjourned issues, if that should prove to be necessary following a successful appeal by the defendants. So as far as the judge is concerned, this is Mr. Justice Morgan, the only time that the claimants are seeking permission to apply for the adjourned issues are if it should prove necessary following a successful appeal. And that, we say, is the right interpretation. It is what objectively the draft order and his understanding as put in this judgment reflects. And then he goes on, it's not said by the claimant that absent a successful appeal, it might wish to seek a determination of the adjourned issues in order to allow it to argue for a wider remedy than the remedy it would be entitled to on the basis of the findings as to the infringement in the first judgment. And again, we say that is all completely consistent with the judge understanding Lufthansa's position that it was never going to be seeking to run the adjourned issues absent a successful appeal. And your lordships, I hope, will have understood why it might have mattered on the appeal, because one of the points in the adjourned issues was this, what's been referred to as the bait and switch argument. And the bait and switch argument only ran in relation to claim 2 of the patent. But as the defendants had been found to infringe claim 1 of the patent, it wasn't necessary for the judge to look at the bait and switch point. But if on appeal claim 1 had been invalidated, or it had been found that claim 1 wasn't infringed, then the claimants might have wished to run the bait and switch point to establish infringement under claim 2. And that, we say, is the context in which this point, it was a very narrow point, where the claimants were concerned that in one possible outcome on the appeal, it might be necessary to run one argument, and that's the bait and switch point alone. And as your lordships have seen, Mr. Justice Morgan thought it wasn't necessary to provide for permission to apply following the appeal, because that is something that could be ordered by this court, and at least having raised it, it was clear it was a live issue at that stage, then this court could have made this appropriate order in respect of that. And so we say that paragraphs 2 and 3 are entirely consistent with the judge reflecting his understanding that the claimants only wished to run the adjourned issues in the event of a successful appeal, and didn't wish ever to say we would like to argue for a wider remedy under the adjourned issues than the judge had found at trial. And that, we say, is crucial, given that the whole point of a quantum hearing and the whole point of adjourning matters to a quantum hearing is in case you want to expand the scope of relief that you recover in monetary terms following a finding of liability. And these statements reflected by the judge in paragraphs 2 and 3 in our submission make it clear that the judge understood the claimants never to be wanting to seek to run the adjourned issues as part of the quantum and relief part of the trial, or part of the action. And that is why he was entitled, and indeed right, we say, to make the order he did, and why Recorder Campbell was right to understand it in those terms. And indeed, we say, this is really a point for later, but I think it's helpful to, as we look at this paragraph now, if it's right that the claimants truly were surprised by the judge's findings, then this is the first red flag. Absent a successful appeal, says the judge. If they thought that they did want to run this point later, then this was a red flag to them, point which you might have expected them to alert the judge to when the judgment was handed down, or appeal, or do something about back in 2020, and not wait until 2023 or 2022 when it was first raised in the pleadings, 2023 to run these points on appeal. We also say the judge, Recorder Campbell, didn't record paragraph 4 in his judgment of Mr. Justice Morgan's relief judgment. We say that's also consistent with everything we've been saying, with what the judge found. That's where he said, I do not see how a successful appeal by the defendants would make it appropriate to determine adjourned issues. That's because by the time he was looking at the question of appeal, the grounds of appeal had been put in, and in his view, the only basis on the grounds of appeal was validity, and so there wasn't in fact a possibility on the grounds of appeal before him of there being non-infringement of claim 1 but infringement of claim 2, and therefore that was a further reason for him to think that it was unnecessary to allow this point to be unnecessary to mention it in the order, given the very narrow basis upon which the claimants had sought to keep it alive, only in relation to a successful appeal, which in fact it didn't appear that the defendants were even seeking to raise at that stage. So that's the first part of his reasoning, and then the second part of his reasoning is set out in paragraphs 12 and 13, which again Recorder Campbell underlined the parts which he thought were most relevant. And your lordships will have seen in those paragraphs, and we've already discussed, reference to the defendant's submissions first of all, in paragraph 12.
I think we're all pretty familiar with this.
Yes. Well, again, particularly the wording in 13, where he says, it's not my understanding of the claimant's position about abandonment. That's another red flag, we say. And if in fact the claimants thought that they were reserving their position for the quantum phase, and this was only to do with liability, it would be very strange for them to read the wording here about abandonment and not be alerted to the fact that they need to do something about it. Of course, they didn't do something about it, which again we say is all consistent with the fact that they were genuinely, and the judge was rightly understanding their submissions, that they did not want to pursue any of these points other than in the context of a successful appeal, and once that had been dealt with, there was no need to deal with them otherwise in the order, except to make the award of costs which the claimants were seeking hand in hand with the submissions that they were abandoning the points. And that's what they were up to. My learned friend put it early. He said, oh, well, it's very strange that he suggested we were saying they must have abandoned it because they sought a costs award. But actually, it was the other way around. They wanted the costs award, and so in order to bolster their arguments about the cost award, they made it clear that they were abandoning these points and they were never going to come back. And therefore, it was absolutely right that the judge should assess the costs at that stage, put a line under these issues forever, rather than leaving it open and leaving some judge at a later date having to deal with the costs when the chances of them returning were, as my learned friend put it in the skeleton before the judge, never.
You say it was to bolster the position. It seems to me it was pretty much a condition, I thought, or the basis of the application for costs. Because why else would you be inviting a court to make an order on issues which hadn't been before the trial judge, hadn't been argued about, and were going to proceed, unless you were saying that you were abandoning them?
Yes. Well, one, of course, there's if you're abandoning things, sometimes the cost order is made against you if you're abandoning it. But in this case, yes, they were the successful claimants, yes, and they were saying these points haven't been dealt with, but and they don't need to be dealt with now. But because we're the successful claimants, we would like the costs. Yep. And so those two submissions went hand in hand, and that's why you need to read the order as a whole. And although in the end it was a dispute about costs, it was a dispute about costs which was connected to whether or not they wanted to run these points in the future. And they tactically decided to express the point on the adjourned issues as they did, or as the judge, at least at this stage, reflected their submissions. And one can understand that tactically. And that's why Recorder Campbell was absolutely right to come to the conclusion he did about the order interpreted in the light of the reasons, and why we say that none of my learned friends' points on this appeal even get off the ground. So again, I don't want to go over parts that your lordship's already looked at. 41 and 42 is where he expresses the points most clearly. Absent a successful appeal, Lufthansa did not want a determination of the adjourned issues. Lufthansa did not want to keep the adjourned issues alive. And that's why Recorder Campbell found that the judge ruled as he did. He deals with the point about the wider remedy, which I've already dealt with in 44. And Recorder Campbell was also influenced by the fact that Lufthansa didn't try to correct the judge, even though he used words such as abandoned in his reasons, and he noted that he hadn't got any evidence from Lufthansa saying why he
Yes.
why he didn't. He was entitled to rely on that as well. And so overall, we say we don't press the point in 47. We don't say it's necessary for you to look at the submissions as well, because it's clear on the face of the order and the reasons. But we do say that if you were to look at the submissions, you would find nothing inconsistent in those submissions with what Recorder Campbell found. And again, he was correct and entitled to make that finding as well. Therefore, for all the reasons he gives, he was right to rule as he did. 48 is the point that's not before you.
Just a small point of
Yes.
detail on that. I realised when I was asking some questions this morning that I was making a factual assumption which isn't necessarily correct. We have, of course, the form of judgment handed down by Miss Justice Morgan on the 21st of August.
Yes.
I was assuming that it was sent out in draft beforehand.
No,
Is
it
that
wasn't.
correct?
It wasn't.
It wasn't,
No,
right, okay.
it was
I'm
sent
glad I
straight.
checked.
Yes. It was sent straight to the parties.
Right.
And of course, had it been sent out in draft, then it might have been possible for my own friends to have written to say that's not what we meant. As it was sent out to them in final form, then possibly the only thing they could do was appeal there and then, but they didn't even do that. So I mean, it might have been possible to have raised it. Yes, and the fact they didn't seek to appeal suggests they also wouldn't have commented on a draft if they'd received it. And we say that's all consistent with the submissions that they thought they were making, and in fact the judge had accepted.
Well, it's perfectly possible to apply to a first instance judge who's made an order on an erroneous basis to say, Judge, very sorry, you've got to reconsider this because you've made it under a misapprehension.
Yes, and that didn't happen either. So, my lords, in terms of the grounds of appeal and the points that were put most forcefully this morning, the point was put in this way. It was said, if the order was to have the effect that Recorder Campbell found it to have, it should have said something more. And that's an attractive forensic way to try and put the point. But we say it's actually a misleading approach, because what the court has to do is to construe the order as it is and not try to think about, well, what could it have said, what might it have said. And the answer to the submission is when you read the order and you read the judgment alongside it, and you read in particular paragraphs 2 and 3 and then 12 and 13 and the reference to abandonment, it is absolutely clear what the judge and the order was meaning objectively, and it's difficult when you take it all into account to see how he could have made it any clearer using the word abandonment as he did. And so we say that first point doesn't take my learned friends anywhere. The other point that was raised this morning was my learned friend said that judge didn't take account of the earlier orders, and he placed weight on the context in which the earlier orders were made by Mr. Justice Nugie and Mr. Justice Marcus Smith. But that puts him in a very difficult position as well, because he also told you that Lufthansa secured safe passage for these arguments to the quantum stage, and indeed he said they were careful to shepherd the issues to the quantum stage. And so his point about the background to the earlier orders is completely contradictory to the point that he was seeking to make at other times this morning, that the judge and the parties were only thinking about liability, because it's clear that everyone was clear that the point of the adjournment was to adjourn everything to the quantum stage, and therefore when Mr. Justice Morgan was being asked to deal with the adjourned issues afresh after trial, that was in the context of the previous orders adjourning them to quantum, but now it was being said they never need to be determined. They don't need to be determined again. That's why we should have our costs. And so the point about the earlier orders and the context in which they were made, we say supports our interpretation and not my learned friend's interpretation, because he's trying to ride two horses at once, which is to say, we were shepherding them to the quantum stage, but oh no, everyone was only thinking about liability when the order was made, and that's just flatly inconsistent. And when we come on to the appeal against Mr. Justice Morgan's order, I'll show you that in fact it was clear that people at the time had in contemplation the quantum stage in any event. The other points that are run, if I'm going back to the notice of appeal, I hope your lordships will understand our submissions on them by now. First point, that Recorder Campbell failed to identify an absence of clear wording. We say there's no requirement for this. The task of the court is just to construe the order and work out its meaning, doing the best that you can. And as the judge found, the meaning was clear when the document as a whole was considered, and so he was entitled to come to that conclusion. The next point on the notice of appeal is that Recorder Campbell ought to have held that the absence of the liberty to apply was insufficient to preclude Lufthansa from asserting the point later, but that ignores the effect of the recital and the change to paragraph 11 together, which remove and do preclude Lufthansa from asserting the points later, because they record that the points don't need to be determined, because as Lufthansa put in the submissions, they had fallen away. Related to this, the judge didn't err in placing weight on the fourth recital for the reasons I've been through in the authorities. He was entitled to take into account the recital alongside the arguments before him, which he resolved in the judgment, and so Recorder Campbell was entitled to use the judgment to indicate the purpose of the order, which we say is clear. We also say, as I've already submitted, that there was my learned friends were wrong to suggest that there was ever an express liberty to apply in paragraph 11 alongside the recital, and so there could be no conflict between the recital and the meaning which Lufthansa argue for. This point, we say, is a pure bootstraps point. There's a clear conflict between the recital and the position the defendants took before Mr. Justice Morgan, and therefore it's wrong to try to dissect paragraph 11 and say the black bits are all agreed and ignore the red bits. The judge was asked to determine the issue of costs hand in hand with the issue of what is happening to the adjourned issues, and he either had to accept the defendant's submissions or the claimants in whether the adjourned issues were still live or not, and then the cost point followed after that. And when you look at both of the parts that were in issue, paragraph 11 and the recital, and you understand the reasons the judge gave, he clearly chose the former point, the claimant's submissions. There was an abandonment of the point, but that was to result in the claimants getting their costs. And the purpose of recital 4 was to record Lufthansa's position. It was in conflict with the defendant's position, and that is why the judge made the order in that term, those terms, and therefore you can't try to compartmentalise the order and only look at paragraph 11 without the recital in mind as well. I've dealt with the point on the Mr. Justice Nugi and Marcus Smith orders. Finally, and I've also dealt with the point that it was only determined in relation to liability only. The whole point of this order was to kickstart the quantum phase, and the wording of the order is contemplates future happenings, what is going to be happening going forward.
Yes.
And that is important, an important part of the judge's order and the reasons he gave for making that order, and the adjourned issues no longer needing to be determined in the light of the court's judgment. That could only be.
Listen, I think we've got.
I'm sorry.
I think we've got your point.
Yeah, I'm grateful. So, my lords, that was all I wanted to say in relation to the Campbell appeal, and I was going to move on to the Morgan appeal next. There are two separate aspects to this: the substantive merits and the relief from sanctions. I will follow my learned friend's course and deal with relief aspect first, because they follow on most easily from the discussion we've already been having. But that is not to underestimate the weight of the case against him in our submission on relief from sanctions. And so, although I will deal with relief from sanctions at the end, we agree with your lordships. Logically, that comes first. And
I mean, I'm perfectly happy for you to deal with it first, so we don't lose sight of it.
Well,
let
me. I'll deal with it in the same order as my learned friend. It might be easier for your lordships. So the first point is the whether or not you can get any assistance from Mr. Justice Morgan's recent judgment, or Sir Paul Morgan's recent judgment. And as I say, we say that this court often looks at further reasons given by a court for allowing or not allowing permission to appeal. And we say for that reason, your lordships are permitted to look at it. And if I can show it to you in the supplementary bundle, because we say it supports all the other arguments that we...
Well, we're getting into we really are getting into a vortex of procedure here. You're now about to show us a judgment given 3 years later by the trial judge. We would need to be satisfied that this was potentially an aid to interpretation. I've no idea whether we would need to be satisfied that this ought to be received by us in the context of an out-of-time appeal. It seems to me to be the whole thing seems to me to be very irregular, that we're simply just washing around between judgments given at various different points in time, which is slightly why I wanted to hear from you in relation to the extension of time point as well, because this is a judgment given by a judge long after the original decision. And so, obviously, now, having been alerted to it, I, for one, have taken the opportunity to see what's in there. But I'm just wondering what, realistically, one can fairly make use of within a document of that kind, produced in this sort of way, in the context of an application for permission to appeal, and for an extension of time of 3 odd years. And I don't want to be in a situation where we're simply following the argument down various rabbit holes because we're being led there without keeping our heads up and seeing where this actually potentially takes us.
Yes, my lord. I think the background to this is that I think my learned friends belatedly realised that the best way for them to resolve the position they are in was to go to Mr. Justice Morgan on the slip rule.
Yes.
And that's why they wanted to get that hearing on before today.
Yes, what I'd like to be satisfied of before we start, obviously my lords may take different points, but speaking of myself, I'd want to be satisfied that we need to know more than the fact that the arguments that have been urged upon us today were urged upon the judge earlier this month, and he rejected them. Now, is it going to be helpful to us, or a proper exercise for us to follow him back down the same old road that you're both going along, paragraph this, recital that, paragraph that, this is what I thought. Is that a proper exercise on this rolled-up hearing, I ask myself?
And before you answer the question, I would emphasise, particularly in circumstances where, as you've just acknowledged, the application made to Sir Paul Morgan was, at the end of the day, put primarily under the slip rule. So it's a completely different exercise. So the exercise there is, did the order faithfully reflect the judge's intentions? Whereas the appeal that is sought to be made before this court is, even if it perfectly reflected his intentions, he was wrong because his intentions were wrong.
I accept that. There were two ways in which the argument was put before him. The application was also put under Rule 3.17, i.e. the power of the court under these rules to make an order includes a power to vary or revoke.
Yes, but he was having none of that whatever either.
Indeed.
I'll tell you what we're going to do. Mindful of the position of the shorthand writer, we'll take a 5-minute break. Now we'll reflect on the situation that's been reached and we'll tell you what we think.
we're missing half of the
I'd better wait.
company.
Do sit down, Mr. Before we start again, I gather that a law reporter was seeking the skeleton arguments. I believe those have now been forwarded. I don't know whether it's by those who are in court or by somebody else. But good. Right. Well, our view is that, that this later judgment in relation to the most recent applications can't properly assist us in relation to the very different tasks that we have. So. Quite understanding, in one sense, why you want to refer us to it. Can we move on beyond that, please?
Of course, of course. My lords, I will deal with relief from sanctions first then. I'll give your lordship's indication.
Thank you.
And our submission is that my learned friends have very real problems in establishing that this court should grant relief in circumstances where Lufthansa has delayed some 3 years in filing a notice of appeal. And even taking into account its failure to realise the problem arising from Mr. Justice Morgan's order, Lufthansa delayed some 7 months from the problem becoming apparent and its notice of appeal. And it even delayed 5 weeks between the handing down of the Campbell judgment and filing of the Morgan appeal, in spite of the express direction in the Campbell judgment that it would need to appeal the Morgan order. And we say all of these points amount to delay for which, when the appropriate test is applied, my own friends and Lufthansa should not obtain relief. Just so your lordships are clear about the timeline, can I just show your lordships the time when this was first raised by the defendants expressly? And this is in the supplemental bundle at tab 40. And it's a letter from Hogan Lovells of 24th of November 2022. And the purpose of showing you this is firstly to show you that all of the points which we're now arguing about for your lordships were raised in this letter. So if your lordships just turn to page 249, you can see that halfway through the page on 249, there is a set of points dealing with the order of Morgan J of 22nd of July 2020 and the submissions and the paragraphs in the judgment, which we've already looked at. And so all these points were raised as long ago, almost a year ago, by those instructing me, and yet Lufthansa still took until June this year to make the appeal that's now before your lordships. The other point to make as a result of this letter is it indicates and demonstrates that the points were raised by Lufthansa in their original points of claim, and the suggestion that it's only in relation to some point made in the defence by the defendants that it became apparent to them that they would need to run these arguments is just not right, given that they were all pleaded out for the first time in the points of claim before Lufthansa had seen the defendants' arguments on the account. And so my own friend's account of how the matter arose just doesn't hold together, I'm afraid, given the order in which the points came about. Now, to put this all into further context, it's clear that Lufthansa...
Sorry, I'm a little puzzled by that explanation because, as one sees from the first paragraph of this letter, this is responding to draft amended points of claim, and presumably that was after service of the points of defence.
No, it wasn't. There was an amendment to the points of claim made before the defence had been served.
Oh, I see. All right. Thank you.
The other document, if I may show you, is the background to, in terms of the evidence from Lufthansa about relief from sanctions. And this is in Friends Structured Solicitors witness statement, tab 26 of the supplementary. It's the 60th statement of Mr. McCulloch. And if your lordships would just read paragraphs 25 to 28, which sets out the background. And so your lordships will see what the position is about the recollection of those in the legal team, at least, at Lufthansa. The other point I'd just like to make, in paragraph 28, Mr. McCulloch highlights profits. This is about 6 lines down. He says, the profits Astronics made on that US supply for the purpose of the onward distribution to the UK is the claim Lufthansa now wishes to make, deriving from the joint tortfeasance between Astronics and Panasonic. So certainly at the time this statement was given, it wasn't the profits that Panasonic were making, which it was said were the purpose of trying to run the adjourned issues. They were focusing in this paragraph on the profits that Astronics were making in the US. And so again, we say that my learned friend's account, oh well, the whole purpose of wanting to run the adjourned issues is in order to catch the profits that Panasonic are making, but which they are denying are covered by the current findings of infringement. That doesn't stack up with what Mr. McCulloch was explaining here, that actually they were trying to chase a completely separate set of profits, that is to say the profits made by Astronics in the US, where of course the patent had already been found to be invalid. But that may be a matter for another day. I don't need to go further than that. The final point on the facts, my lords, is just to explain about Lufthansa's position. And if your lordships will go to, as opposed to Lufthansa's legal team position, if your lordships will go to tab 5, please. And this is a statement from Mr. Bennett, that's the defendant solicitor, made in March 2023. And if your lordships would go to page 49 and paragraph 51. And your lordships can see that as far as Lufthansa were concerned, they were already seeking an account of profits in Germany for equivalent proceedings under the German patent as long ago as July 2017. And that's not surprising, given that Lufthansa are not themselves manufacturers of the equipment claimed by Claim 1 of the patent. And so they were never likely to be wanting to seek damages, as they were not manufacturers, and that indeed
that wouldn't stop them getting damages on a reasonable royalty basis, and it's commonly done.
It is there is a plea in the pleadings about the reasonable royalty, and they accept in their reply that the licensee to whom they've licensed this patent hasn't in fact made much money because they can't make the seats properly, and so therefore there's not even much in the way of reasonable royalty either. But the point I would seek to make, my lord, is that it was clear to Lufthansa that an account of profits is a valuable remedy for them in this particular case. And there's further reason to think that Lufthansa and those who would instruct should have had this in mind much, much earlier than it is said on the evidence that this point arose. So, my Lord, when we don't have any evidence of what Lufthansa were thinking at any relevant time, we have evidence of what the legal team can recall, but one must presume that the request before Mr. Justice Morgan to get costs in return for giving up the adjourned issues was made on instruction, and therefore Lufthansa themselves, given that they were aware of the account of profits in Germany, can be expected to have had everything relevant in mind at the relevant time. Further, it's clear that the issue of an account was at least in the contemplation of the parties in the UK as well, and if your lordships go to tab 27 of the supplementary bundle, you can see a letter before the trial. This is written on the 30th of October 2019 by Jones Day, Lufthansa solicitors, and on page 203 in the second full paragraph, you can see that Jones Day say the last sentence, furthermore, the scope of and approach to a quantum trial is liable to be fundamentally informed by the outcome on liability, including, for example, whether our client wishes to seek an account of profits or damages. So it was clear to Jones Day that the option to seek an account of profits was very much live, and this was even before the trial took place. So all of that is in the context of an application before Mr. Justice Morgan for Ireland Records disclosure to enable the choice for Lufthansa between damages and an account. And our submission is that it's clear that with all this in mind, Lufthansa and its legal team ought to have had the issue of an account in mind and ought to have foreseen the consequences of what it was asking for and what it was giving up by abandoning the issues, or at least what Mr. Justice Morgan had decided they were asking for in his judgment when he held that they were abandoning the issues. And we say all that puts into context the delay that has taken place since, and we say that it all feeds into the reasons why your lordship should not grant relief from sanctions in this case. So if we turn and try and apply this to the legal approach, my learned friend, there was another appeal in this matter before this court a couple of weeks ago, and my learned friends in that case spent much of his speech reminding the court of the change in approach required by the Jackson reforms, and he quoted extensively from Lord Dyson's speech to the district judges in March 2013, which I'm sure your lordships are familiar with. We've got it in the authorities bundle at tab 10, in which Lord Dyson pointed out that the overriding objective did not require putting justice between the parties as the most important factor in any decision, and that the renewed focus on compliance and proportionality is in the interest of other court users and the wider public at large. And we can see that, again, it may not be necessary to turn to it, but paragraphs 21 and 23 of that speech underlie all of the policy reasoning behind the Jackson reforms. And with that policy in mind, the limbs of the test are now well established. Firstly, the court needs to ask, is the breach serious and significant? In this case, we submit it is both serious and significant. It's serious because the application for permission was made almost 3 years after the order, when the rules state that it should be made within 21 days. We suggest that this court would not welcome a deluge of applications filed so long out of time, and there's no suggestion that the original sanction, that is, if you don't file your notice of appeal within 21 days, you can't appeal, no suggestion that that time period is disproportionate. And that's one of the relevant considerations which the court should bear in mind, and that's explained in paragraph 40 of the Durant case, which is one of the well-known cases on the Jackson reform. reforms and relief from sanctions. And the reason why this 21-day period for a notice of appeal is important is that it would undermine certainty, and it would undermine the proper administration of appeals in this court. And the leading case on relief from sanctions for notice of appeal is the HISAG case, which is at tab 8 of the authorities bundle. And that was a rolled up decision. There were 3 different cases before the court, and Lord Justice Morbitt gave the leading judgment. There was a case where the notice of appeal had been filed 42 days late, another one where it had been filed 9 months late, and finally one which had been filed 5.5 years late. The reason for the 42-day delay was because the parties had agreed a timetable for filing the notice of appeal, but had failed to apply to extend time from the court. And Lord Justice Morbitt decided that in that case he would reverse the judge below and he would allow relief from sanctions. But the other 2 cases, the 9-month delay and the 5.5-year delay, he decided that relief from sanctions should not be granted. And if we can pick it up at paragraph 54 on page 151, he explains in 54, he contrasts it with the previous case. He says this delay is much longer than that in the previous case, and in general, the longer the delay, the less willing the court will be to extend time. Of course, the applicant may in some cases be able to satisfy the court that the delay, although substantial, has not had any practical effect on the course of the proceedings, but the longer the delay, the less likely it is that he will be able to do so. Then he refers to the delay in that case, which was merely a delay to pay some costs. And he says, even though it's only in relation to costs, the delay has had a commensurate effect on the progress of the appeal. One reason for limiting the time for filing notice of appeal is to promote finality in litigation. Parties need to know where they stand. Delay of the kind that occurred in this case undermines that objective, and in my view it was both serious and significant. And he then went on to observe that even once the delay had been, that the fault had been notified to the solicitors, there was a further delay in taking action to take steps to file the notice of appeal. This is 56. And he says, in this case, I don't think there was a good reason for failing to file a notice of appeal in time. He then goes on to say that there would be prejudice to the claimant if the court were to grant the extension. This is 57 at F, and the defendant will suffer prejudice if he's prevented from pursuing the appeal, but he says that's of his own making, and he goes on to refuse relief from sanctions in that case. And then the final case with the 5-year delay is on page 153 is 61, and he says that delay is E. That delay is very serious and also very significant in the sense that the position in relation to costs has remained undisturbed for a long time. There would have to be exceptional reasons for allowing the defendant to reopen the position now, and there are none. So, my lords, we say the delay in this case is clearly significant. We also say that, sorry, it's clearly serious. We also say it's significant in that much water has flowed under the bridge in terms of the progress of the account, and this is now the 5th hearing in which this order has been discussed. There's been a massive waste in our submission of the resources of the parties and also the court in trying to deal with this issue, and that's precisely what the Jackson reforms were meant to curtail. Further, we say that if the appeal were to succeed, it would have a significant detrimental effect on the trial timetable. And this is explained by Mr. Bennett in his 11th statement at Supplemental Bundle tab 3. Sorry, that's a bad reference. Supplemental tab 33. And your lordships, I could ask your lordships to read on page 212, your lordships read 37 to 39, please.
Yes.
And if you could also read, please, paragraphs 51 and 52.
Yes.
And this disruption to the trial timetable doesn't seem to be in dispute. Can I take you, please, to the core bundle, tab 3. And this is the letter from Lowe Jones Day seeking expedition of this appeal. And if your lordship turn to page 20, the reason they give for requiring expedition is in the middle paragraph of the page in between the two hole punches, and they say the second sentence, the second and third sentence, they say this would require significant additional disclosure, comprising disclosure on both the joint tortfeasance itself and also on the revenue and costs associated with sales by Astronics to Panasonic, which Panasonic subsequently supplies into the UK. Both of these categories are likely to be significant disclosure exercises. So we say there's no dispute that if these issues were to be introduced into the account, an account which is already very heavy and teeming with points, there will be a very significant additional disclosure burden. The timetable for fact witnesses would be put at risk, and this would also have a knock-on effect on the preparation of expert evidence. And although the account is not due to be heard until October next year, we say that the effect of the Lufthansa's delay is significant in terms of the way that the account can be managed before it is heard. So that's serious and significant. Then there's why the breach occurred. This is the second head under Denton and Mitchell. Yes. And Mr. Bennett has summarised the evidence from Lufthansa, which you've looked at directly in his statement at paragraph 40. There's no satisfactory explanation why the breach occurred in the first place in our submission. The fault is entirely down to Lufthansa. They can't blame any third party for not realising that the point was against them. In our submission, Lufthansa and or its legal team ought to have been aware of the potential relevance of the point because it was already seeking its account in Germany, and the fact that Lufthansa knew that it didn't make products itself. And there's no good reason for the 7-month delay between November 2022 and June 2023 at all, even if my learned friends are somehow excused not realising the point against them in the light of Mr. Justice Morgan's judgment way back in August 2020. And we underline that we don't understand the argument that the point only arose when Panasonic argued in its defence that it made no profits, when, as I've explained, the argument was raised by Lufthansa in the points of claim before seeing the defence. And as you've seen in the witness statement of Mr. McCulloch, it was Astronics, not Panasonic, against whom the claim that it's now sought to be extended was said to be directed. And as this court explained in the Mitchell case at paragraph 48, unintentional or even well-intentioned incompetence for which there is no good reason should not usually attract relief from sanctions unless the default is trivial. Lufthansa accept that the default is not trivial here, and we say because it's serious and significant in all the circumstances of this case, it should not be, relief from sanctions should not be allowed.
Can I ask, in relation to, you pray the delay from, as well as the earlier delay from the 22nd of November 22, Mr. Bennett's letter?
Yes.
However, the period from then till now, has that delay actually had any real consequence? Because we would have been here today anyway on the appeal from the Deputy Judge, so that the overall issue wouldn't have been determined until today anyway. So what does it matter in that context that the appeal from Morgan is heard today, and in fact, in some ways, it's sensible and proportionate that it should all be dealt with together, rather than having had an earlier appeal on that issue.
Well, I accept that given where we are, it is convenient to everybody to have the both appeals heard today. But the point I would make is that had Lufthansa appealed Mr. Justice Morgan's order at the time it was made,
Yes.
and that would have been heard as part of the main appeal in November 2021,
Yes.
none of these satellite
I understand, but
disputes...
that wasn't the point I was asking.
I'm so
about,
sorry.
though.
I'm so sorry.
I was asking you about. You're making a further point that that on their case they didn't understand the position until.
Yes.
And you say, well, they knew on the 22nd of November,
Yes.
when they got that letter. And my point is that that period doesn't seem to me really matters very much.
I understand what your Lordship's pushing to be, but even then they haven't shown... your Lordship may be right that the net effect of their delay is not... We'll still be here today because the Campbell appeal would have come on when it came on.
Yes.
But there has been significant additional expense and court time by having the slip rule application heard as well in the intervening period. And had we've been vexed 3 times effectively, and had they could have filed the appeal in November last year, and they could have had this appeal on in March or April, say. And if they're right, we never needed to have the Campbell hearing at all,
Well, that's true.
or the slip rule.
So, so your point would, I imagine, be that they shouldn't be in a better position from having lost in front of the recorder. That's just pulling themselves up by their own
It
bootstraps.
is, and if the recorder is right, and the order means what it does, and the way that they should have dealt with this in the first place is to appeal Mr. Justice Morgan, then we've had an enormous waste of time and resources, and my solicitors have been taken away from preparing from the account proper by worrying about all these peripheral issues, and that has had a very prejudicial effect on everyone's preparation for trial. And so we say there is real prejudice as a result of the additional delay after the letter of November 2022. And I think that's really the point that Mr. Bennett makes in his paragraph 40.
Yes,
that's where he's summarising. I've already dealt with that.
All right.
So-
How are we getting on, Mr.
We're getting on well, my lords. So the final point is all the circumstances of the case, and you take into account the serious and significance, and the more serious and significant it is, the more that weighs in the third limb. We say, if you look at Lufthansa's conduct in failing to appreciate the potential significance at the time, when the only issue going forward was the inquiry and account, and they should have had in mind the potential issue in the light of Mr. Justice Morgan's judgment. The defendants have been blameless. They can't be blamed for any of the delay. The prejudice to Lufthansa, we accept that the court can't look at the merits fully, and shouldn't do that as part of this, but we say that the attempt to obtain Astronics profits made upstream in the US, where the patent claim is not valid, is extremely ambitious, and that is something you can take into account as part of this. On the other hand, the prejudice to the defendants is very real for the reasons I've given. And finally, the court has, in 2 of the leading cases, Highsage and Tibbles, been able to infer prejudice simply through passage of time. And when this very lengthy period of delay has taken place in this case, we say that the court can infer, in addition to all the material that you've seen from my solicitors, infer that this has been prejudicial. There has been a significant waste of court resources and money on the part of the parties, and we are putting at risk the efficiency of the justice system. We are taking court time when other litigants should be here instead, and for all those reasons, when properly applied, there should be no relief from sanctions. So that's the first part of the Morgan appeal. Then we get on to the merits. The way in which it was put in writing in the notice of appeal, the grounds of appeal by my learned friends, they say it's clear that the order should not have been made by Mr. Justice Morgan. My learned friends rather rode back on that today. He accepted that there was some ambiguity in the way in which the arguments were put before Mr. Justice Morgan, and so we say that makes it even more difficult for him once he accepts the way in which the submissions could have been understood by Mr. Justice Morgan, and indeed we say it was right for Mr. Justice Morgan to understand them, because it's clear when taken altogether what the claimants were asking him to make, the order they were asking him to make. You have seen the judge's explanation as to why he made the order. I'm not going to go back over that. The evidence you've also looked at, that was the evidence from Mr. McCulloch at tab 12 of the supplemental bundle, and his paragraph 5, where he explained that the adjourned issues are no longer necessary. This is after the judgment, are no longer necessary, and accordingly have fallen away. See the fourth recital proposed by Lufthansa. The question thus arises as to how to deal with the costs of them. So that is a prospective statement, not a suggestion that this is only a liability issue, and that although they might not be needed to be determined for liability, they would still be needed to be determined for quantum purposes. And of course, even that isn't a clear distinction, because in order for Lufthansa to rely on these issues, liability still has to be determined as part of this phase of the trial. So it's not even right to try to artificially divide these points into liability phases and quantum phases, because the adjourned issues had not been determined at all, and so both liability and quantum would need to be taken forward as issues, and the clear impact of, in our submission of Mr. McCulloch's statement here, is that it was no longer necessary for those to be determined for either of those two reasons. Then we have at the same time Mr. Bennett's statement was submitted. This is just in advance of the hearing or the determination by Mr. Justice Morgan. That's in tab 13. And my learned friend did take you to that, but he didn't take you to paragraph 15. And in paragraph 15 on page 110, Mr. Bennett recorded the history of how the issues had come not to be dealt with, and he explained about there would need to be cross-examination of the defendants' witnesses, and he explains at the bottom of 110, due to the added complexity of the trial being held remotely, it was agreed between the parties in correspondence that the cross-examination of Mr. Joper, Mr. Rose and Mr. Williams, the fact witnesses for Astronics, Panasonic and Safran respectively, would be adjourned to any damages inquiry. So again, the suggestion from my learned friend that no one was thinking about damages inquiry when the judge...
Well, I mean, we've got all this, and we're not a jury. We have the situation where you're arguing against yourself and he's arguing against himself. We've got the picture. If there's any particular part of the evidence that is new, we'd be glad to see it. But if it's simply what we've seen already, we've got the points that are right.
Of course, the next place I was going to take you to is the submissions. My learned friend dwelled on some of them this morning, but then no doubt because of pressure of time he didn't dwell on some of the later points in the submissions, and I would just like to highlight, but can I just give you the list of paragraphs that we say are relevant? I'm sure your lordships have looked at them already. This is tab 9 and the submissions before Mr. Justice Morgan. So paragraphs 4, which you looked at, the unless and until they become necessary to resolve. Following judgment, however, it's no longer necessary to resolve them. Paragraph 9.
Yes. Just give us the numbers.
Sorry, 4, 9, 10, 14, 15, 16, 17, 18, 29, 30, 37 and 39.
You would summarise the points arising from that.
Yes,
as being-
and it's the repeated statements that it's no longer necessary to resolve these
Thank you.
issues, and the statements that not only is it no longer necessary, but in paragraph 15, the skeleton seeks to draw an analogy between preliminary issues and summary judgment decisions and the case before the judge. And it's said at the end of 15, the usual order is that the defendant gets all its costs of the action, including of the points of substantive defence, which will never be decided. And then they go on to apply this analogy to the present case, and they say in 16, the problem with that suggestion, the second sentence, is that because the adjourned issues no longer need to be decided, in the absence of a successful appeal, the only
Yes.
direction, etc. And then in 17, they repeat the never wording that we have in 15. And then in 18, they say, in the event of a successful appeal only. So it's making clearer and clearer on each occasion that it really is an abandonment. They are saying that they never need to be determined. And it's clear in paragraph 39, in particular, that this is a future contemplation. Unless an appeal is successful, the adjourned issues do not need to be decided. And if the appeal is not successful, it would be rather unhelpful for this court to leave the instance of the matters over to another judge. So we say that taken together, all of these paragraphs make it clear that the judge was right to understand that Lufthansa were abandoning these points forever, and they were not just abandoning them for liability phase, whatever that's meant to mean. They were abandoning them for the future quantum phase, including the account of profits,
Yes.
which is expressly referred to in paragraph 37. And so we say it's wrong for Lufthansa in their submissions to try to portray this dispute as one about costs alone. We've seen that the issue of costs is intimately related to the dispute about whether the adjourned issues remained open or not. That was, we said that they remained open, they shouldn't have their costs. They said the opposite, and the judge agreed with the claimants. And both positions are understandable, and one can see for tactical reasons why Lufthansa might have been saying what they said at the time, and indeed why the defendants might have been saying what they said at the time. But the fact is, once you've made that submission, the judge has accepted it, you're stuck with it. And we say that there was plenty of material before the judge for him to come to his decision as he did. Indeed, we note that my learned friend himself characterises the parties' positions before Mr. Justice Morgan as strategic in paragraph 16 of his skeleton before your lordships. And we say he's entitled to put it that way, but the problem for him is what do you do when you make a strategic decision in litigation, but you then seek to change your mind? And that, of course, is not part of the appeal before your lordships. My learned friends are stuck with the decision that they asked Sir Paul to make, and which he went on to make. I think I've dealt with the liability and quantum point. We say the judge was right and justified to think that the adjourned issues would only return if there was a successful appeal. That's made plain by the submissions. I've explained the bait and switch point and why he thought as he did. Yes, I think the final point I just need to address is the suggestion that the wording in red in paragraph 11 related only to timing. And your Lord, my Lord, Lord Justice Peter Jackson has already had a discussion with my friend about that. We say it can't relate only to timing, and it doesn't make any sense to suggest it relates only to timing, because the only way in which one can see that timing might come into it is if there was a decision by Lufthansa either to progress the account or inquiry pending appeal, or to wait until after the appeal before progressing the inquiry and account, as in fact they did. But if the inquiry was to go ahead and pending appeal and Lufthansa wanted to move forward, then why should there be liberty to apply on the adjourned issues only arising after the appeal, when liberty to apply on all the other issues would be granted immediately, because it would make no sense to start separating the issues on the account, depending on whether or not steps were being taken before the appeal had taken place. And so we say that this suggestion that the wording in red is something to do with timing alone is an ex post facto suggestion. It's not supported by any evidence, and it doesn't make any sense in the context of the possible routes which Lufthansa might take in relation to progressing the account. So, and we also suggested it just on the plain wording of the order. That's not what insofar means. It's not a term which is used in relation to timing alone. So we say that apart from the appeal point, the judge had every reason to understand that Lufthansa was making a concession, that it would not argue for a wider remedy based on the adjourned issues. And the judge was fully entitled on the material before him to conclude that Lufthansa had abandoned the adjourned issues in relation to in return for getting its costs. That's precisely what it was urging the judge to do, and it's what the judge acceded to. When you look at all the material, it is impossible to say that the judge fell into error in holding that what he was being asked to do was to determine that the adjourned issues never needed determining, and to award the costs on that basis. For all those reasons, we say that you should also reject the applicant's application for permission to appeal in relation to the Morgan order. Unless I can assist your lordship any further, those are our submissions.
Thank you, Mr. Mitchell.
Well, with your leaves, I have a few small points in reply.
By all means.
I'm grateful. My Lord Justice Arnold already addressed the first one when you asked whether the relief judgment was supplied in draft. It wasn't simply that it wasn't supplied in draft, it was provided at the same time as a final judgment with the sealed order. So the two could only be interpreted together. And I say that goes some way to explaining how they were in fact interpreted, because if you read the order first, you think...
Then we'll refer to
no harm, no foul.
Yes.
The second point is the status of the proceedings as at August 2020. My learned friend's submission that the trial order is looking prospectively at the quantum stage. We don't think that's quite right. If you look at the trial order, and you don't need to turn it up again, you're very familiar with it. What it's doing is recording the outcome of the trial judgment. It's setting out declarations, it's dealing with costs, and it's dealing with established entitlements. It isn't giving quantum stage directions. It is permitting the existence of a quantum stage. It's giving, making an order for an election and for island and trim disclosure to inform that election. But we say the quantum stage proper doesn't itself begin until there is an election. And instead there's a sort of interstitial stage which is mopping up liability and then dealing with the election itself as between two alternative quantum stages. The third point is, my learned friend quoted with approval the requirement that on the first appeal, the objective is interpreting the words of the order. He then proceeded to provide almost no submissions whatsoever on the words of the recital, almost no submissions whatsoever on the words of paragraph 11. His case is based almost exclusively on interpreting the judgment. But that's not actually the role. The role is to interpret the words of the order in the context of the judgment. You don't get to set aside the order and only look at the judgment. And similarly, no submissions whatsoever on the words of paragraph 286 of the trial judgment or paragraph 29.3 of the recorder's judgment. And that's very telling. And it's telling on both appeals, because we say if you just start with those words, there's nothing there. There's nothing there to give effect to this outcome. Final point on the first appeal relates to the relevant materials for interpretation. The deputy judge decided in terms that he wasn't going to look at the evidence and submissions, and there's no respondent's notice in relation to that. So on the first appeal, we say it's not open to this court to look at the evidence and submissions as my learned friend did. My lord, that then takes me to the second appeal. Sanctions delay. We don't consider that as a very fair reflection of how things truly unfolded. We pleaded our points of claim out in September 2022, and we included reference to both adjourned issues and unresolved issues without identifying them as such, because at that time we were unaware that there was any objection to be taken. So we weren't on notice that there was a problem, or said to be a problem, until receipt of that letter. Now, upon receipt of that letter and the points of defence in December, we did take steps. We applied to bring the matter to a head in the CMC before the recorder. We got an order from the recorder on the 5th of June, and the appellant's notice was on the 17th of June. So we don't say there's any delay there, but there's another important complicating factor. All the arguments on convenience and prejudice and behaviour were based exclusively on the adjourned issues. But that's not the only matter that has been in issue before the courts. My learned friend's position was that the unresolved issues were abandoned. So that had to be sorted out as well. And the unresolved issues were not addressed in the trial order. So we were left with an option. Do we do two sets of proceedings? Do we do an appeal and an application and go off in two different directions? Or do we try to understand the meaning of the trial order at first instance as a first step? And then, if that went against us, it would be open to us to try and appeal out of time. And I stand by my position that that was a sensible and appropriate procedure to adopt.
Could I just check this? You say that you went ahead and pleaded the unresolved issues and the adjourned issues all together.
Some of them, yes.
But I mean, whatever you may have understood, you must surely have understood that the adjourned issues had been adjourned with liberty to apply by both of the two prior orders. So it may as a matter of fact be true that you simply went ahead and pleaded them, but you weren't entitled to do that, were you?
Well, I think
without having the court's permission.
That may be right, but given that they had been adjourned so that they could be revisited.
Yes, but it wasn't for you, unless you explained that I've got this wrong. It wasn't for you simply to put them in a pleading.
My lord may be right, and
if there's a may, I'm happy to retreat.
No.
But if it's actually I am right, then in a sense I'm not quite sure what you're able to gain from the fact that you simply went ahead and did it.
So I think my answer is, I think given the purpose of the adjournment was to allow them to be revisited, it would have been an application which couldn't be resisted. So perhaps formally.
Well, it sounds as if it would very much have been resisted.
Well, yes,
as it happens.
But it's resisted because that's been set aside. So if let's consider the counterfactual, where the trial order says liberty to apply generally at the quantum stage in relation to the adjourned issues.
Yes.
And then we plead our points of claim, and we think, oh, these are actually, now we're going for an account. Some of these are of interest to us, and we include them. One might say, well, that should be presaged by an application for liberty to apply, but given its four square within the basis upon which the adjournment was made, I don't think it would be unreasonable.
I'm only making the point that even if you were right, I'm accepting for the purpose of this question, let's suppose you're right that you couldn't have been expected to see what was just about to hit you.
Yeah.
Anybody could have been expected to see that point, that you weren't simply entitled to file a pleading referring to matters which had been adjourned with liberty to apply.
There may not be much between us. I mean, as in, it might not be an absolute entitlement, but as I say, I think obtaining that permission would be utterly straightforward, given the purpose for which the permission was enshrined.
Well, strictly speaking, I think the analysis is, and it's my fault, I think I introduced this terminology this morning, what you needed was to apply, and then that might be consented to by the other side, or in the absence of consent, then the court would have to make a decision. And it might have been a rather minor case management decision, but for the issues with which we are concerned. But nevertheless,
right.
That's formally speaking, that would have been the position.
I think that's probably correct. But the position with the unresolved issues also gives some colour to my learned friend's complaints about repeatedly being vexed, because of course we have been vexed with the proposition that we're not able to revisit the unresolved issues, and we had to go to court to establish that we could. So there's rather more equality than my learned friend lets on. Two final points. Firstly, my learned friend had some submissions about the motivation for revisiting the adjourned issues, and he took you to Mr. McCulloch's 16th witness statement and said it's all about this joint tortfeasance over in the United States. He didn't direct you to paragraph 20 on page 194, which suggests that that's a rather incomplete summary of the position. And then the final point is simply to note that the scope of disclosure in the account has not yet been the subject of any consideration at first instance. So whilst Mr. Bennett might have thought that would have been done by now, it hasn't.
Sorry, I'm a little puzzled as to exactly what you mean by that. Are you saying there's been no disclosure yet at all?
There's been no... So there's a further CMC which is forthcoming, at which disclosure will be entertained in substance for the first time.
I'm sorry, but what does that mean?
No disclosure has been given. There's been no disclosure given.
Right, that's clear. Thank you.
And no date for disclosure has been set down. My lords, unless I can assist you any further.
Thank you very much indeed. Well, our thanks to Council, those who support them, for the very helpful submissions that we've been hearing. We'll obviously think about this and let you have our decision and judgments in due course. You know the protocol. These are only to be disclosed to those who are on the approved list, and you'll please let us have corrections and a draft order agreed. And we will then make our orders without the need to trouble you further. Thank you very much indeed.